This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about what happens when you wrongfully state on an application for a CGL the kind of work you do. And if you claim you don't install playground or recreational equipment, and you do, you may find you have no coverage because a policy only covers damages caused by the kind of work you tell the employer and the insurer what you do. And if you install an in-ground trampoline and don't tell your insurer on your application that you will work on recreational type equipment, you may be in trouble. United Casualty Insurance Company refused to defend James Snell, a landscaper, in a civil lawsuit alleging that Snell had negligently installed a ground-level trampoline in a client's backyard. Snell sued, contending that United had breached the insurance contract with him in bad faith and seeking a declaratory judgment that United had a duty to defend and indemnify him. The district court granted summary judgment for United, holding that the accident did not arise from Snell's landscaping work within the meaning of his commercial general liability policy. The 11th Circuit resolved the dispute in James Snell, d.b.a. Outdoor Expressions versus United Specialty, a decision of the 11th Circuit Court of Appeal on May 28, 2024. Snell's landscaping company was called Outdoor Expressions, and it's located in Fairhope, Alabama. Snell was hired by a family called the Westons to turn an above-ground trampoline into a ground-level trampoline. Snell's site work included excavation of a pit, installation of a drain and drainage sand, excavation of a trench to install a drainage pipe, installation of the drainage pipe and a drain pump, and most relevant here, construction of concrete block retaining walls and installation of a wood cap on the retaining walls. The retaining walls were aimed to prevent erosion and collapse of the structure, and the wood cap was for aesthetics. Then, after all that, Snell unboxed the trampoline, assembled it, and lowered it into the pit. A few years later, Matthew Burton sued the Westons for injuries his daughter suffered on the Westons' trampoline. Burton alleged that Snell wantonly assembled, constructed, and installed the trampoline in the backyard of the Westons' home, creating an unreasonably dangerous condition and structure on the property. Snell advised his insurer of the lawsuit, only to have United advise that they would not defend him nor indemnify him because of the policy's obligations were limited to the specified operations that Snell, as an insured, performs as landscaping. It concluded that the injury from the assembly and installation of a trampoline did not arise from Snell's performance of landscaping, and that there was no coverage for such claims. In addition, the application, which predated the policy, specifically asked Snell, quote, "Do you do any recreational or playground equipment construction or erection?" Close quote. In response, Snell checked the no box. Snell had the burden to show that there was coverage. Under Alabama law, the party seeking coverage under a policy bears the burden of proving that coverage exists. In short, the specified operations provision, fitting into the gap left by the general coverage provision, describes the contours or boundaries of coverage. It does not purport to take away coverage already granted. Because Snell's insurance application, which Alabama law required the 11th Circuit to consider part of the policy expressly disclaims the work he did. Under Alabama law, insurance contracts are subject to the same rules of interpretation as any other contract, and it was undisputed that the trampoline was recreational equipment. Accordingly, the 11th Circuit concluded that the information Snell provided in his insurance application conclusively established he was not entitled to coverage. The 11th Circuit concluded that Snell's insurance application foreclosed any duty to indemnify for the same reason it forecloses any duty to defend. Generally, to prove a claim of bad faith, which he thought existed even if there was no coverage, to pay an insurance claim, the plaintiff has the burden to prove 1, the existence of an insurance contract, 2, an intentional refusal to pay the claim, and 3, absence of any lawful basis for the refusal and the insurer's knowledge of that fact or the insurer's intentional failure to determine whether there is any lawful basis for its refusal. The district court, having found that United had a lawful basis for denying Snell's claim and that Snell's breach of contract claim failed, his claim for bad faith denial also failed. Snell did not show it was error to grant summary judgment on his bad faith claim, and therefore the 11th Circuit affirmed the district court's decision. In my opinion, the commercial general liability insurance policy issued to Mr. Snell insured Snell against many risks of loss as long as they occurred as a result of his occupation as a landscaper that had no act that did not include any recreational or playground equipment, construction, or erection. Since the trampoline he installed was clearly an item of recreational or playground equipment, there was no potential for coverage to exist to defend or indemnify Snell for the injuries incurred when a child using the trampoline injured herself. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and have access to the more than 4,800 blog postings. You can also subscribe to the videos on YouTube and on rumble.com. Both are free. And if you do, I'd appreciate it if you click on the like button on the YouTube video or on the thumbs up button on the Rumble video. And if you're interested in further detail about insurance claims, insurance fraud, and insurance law, please consider for a small fee subscribing to my Substack publications. Thank you for your attention.